Welcome to The Docket. I'm your host, Corey Snow. This is episode 24. On December 11, 2023, Special Counsel Jack Smith filed a petition for a writ of certiorari to the United States Supreme Court, asking that the court immediately take up the question of whether a former president is immune from prosecution for charges of crimes committed while in office. This is in response to Donald Trump's appeals to the 11th Circuit in his Washington, D.C. criminal case, which would potentially take many months to resolve and delay the beginning of Trump's trial. A writ of certiorari, which is what Smith is requesting with this petition, is how the Supreme Court indicates that a case will be heard. What follows is a narration of the petition filed by Smith. Citations and footnotes may be omitted or simplified for listenability. Also, the original document contains 60 pages of appendices, which are not recorded. The original document, including all citations, footnotes, and appendices, is available at a link provided in the show notes. In the Supreme Court of the United States, United States of America, Petitioner v. Donald J. Trump. On petition for a writ of certiorari before judgment to the United States Court of Appeals for the District of Columbia Circuit. Petition for a writ of certiorari before judgment. Jack L. Smith, Special Counsel. J. P. Cooney, Deputy Special Counsel. Michael R. Dreeben, Counselor to the Special Counsel, Counsel of Record. James I. Pierce, Assistant Special Counsel. Department of Justice. Address omitted. Question presented: whether a former president is absolutely immune from federal prosecution for crimes committed while in office or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. Related proceedings and table of contents omitted from audio. The Special Counsel, on behalf of the United States, respectfully petitions for a writ of certiorari before judgment to the United States Court of Appeals for the District of Columbia Circuit. Opinion below. The opinion and order of the District Court is not yet reported but is available. Jurisdiction. The judgment of the District Court was entered on December 1, 2023. Respondent filed a notice of appeal on December 7, 2023. The Court of Appeals jurisdiction rests on 28 U.S.C. 1291. The jurisdiction of this court is invoked under 28 U.S.C. 12541 and 2101E. See e.g. Biden v. Nebraska 2022, granting certiorari before judgment on a petition filed by a party that prevailed in district court. United States v. Nixon, 1974, same. Constitutional provisions involved. Relevant constitutional provisions are reprinted at Application Infra 60A. Statement. This case presents a fundamental question at the heart of our democracy: whether a former president is absolutely immune from federal prosecution for crimes committed while in office or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. The District Court rejected respondents' claims, correctly recognizing that former presidents are not above the law and are accountable for their violations of federal criminal law while in office. Respondent's appeal of the ruling rejecting his immunity and related claims, however, suspends the trial of the charges against him, scheduled to begin on March 4, 2024. It is of imperative public importance that respondents' claims of immunity be resolved by this court and that respondent's trial proceed as promptly as possible if his claim of immunity is rejected. Respondent's claims are profoundly mistaken, as the district court held, but only this court can definitively resolve them. The court should grant a writ of certiorari before judgment to ensure that it can provide the expeditious resolution that this case warrants, just as it did in United States v. Nixon, 1974. 1. Respondent served as the President of the United States from January 2017 until January 2021. The indictment alleges that Respondent engaged in systematic and deliberate efforts to overturn the results of the 2020 presidential election and prevent the lawful transfer of power to his successor. On August 1, 2023, a federal grand jury sitting in the District of Columbia charged Respondent in a 4-count indictment. Count 1, which charges a conspiracy to defraud the United States in violation of 18 U.S.C. 371, alleges that Respondent, then a candidate seeking re-election to the presidency, conspired with, among others, several individuals outside the executive branch to, quote, overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. End quote. The indictment further alleges that Respondent aimed at accomplishing the conspiracy's objectives in 5 ways: using deceit toward state officials to subvert the legitimate election results in those states, using deceit to organize fraudulent slates of electors in 7 targeted states, leveraging the Department of Justice to use deceit to have state officials replace the legitimate electoral slate with electors who would cast their votes for Respondent, attempting to enlist the Vice President to fraudulently alter the election results during the certification proceeding on January 6, 2021, and directing supporters to the Capitol to obstruct the proceeding, and exploiting the violence and chaos that transpired at the United States Capitol on January 6, 2021. Counts 2 and 3, which incorporate allegations from Count 1, charge conspiracy and substantive violations of 18 U.S.C. 1512 C.2 for corruptly obstructing the certification of the presidential election results on January 6, 2021. Count 4, which likewise incorporates the allegations from Count 1, alleges that Respondent conspired to violate one or more persons' constitutional right to vote and have one's vote counted, in violation of 18 U.S.C. 241. The District Court scheduled the trial to begin on March 4, 2024, with prospective jurors set to complete questionnaires on February 9, 2024. Central to its selection of a March 4th trial date was the District Court's recognition of the public's right to a prompt and efficient resolution of this matter. 2. Respondent moved to dismiss the indictment on the grounds, inter alia, that he enjoys absolute immunity from criminal prosecution for acts taken within the, quote, outer perimeter of his official responsibilities, and that the indictment's allegations all fall within that scope. He also argued that double jeopardy principles and the impeachment judgment clause of the United States Constitution barred his prosecution. The government responded that a former president has no such absolute immunity from federal criminal prosecution, that even if such immunity existed, it would be narrower than the outer perimeter standard that defines a president's immunity from civil liability, that even if that standard applied, the indictment should not be dismissed because it alleges conduct falling outside the outer perimeter of a president's official responsibilities, and that Respondent's double jeopardy argument lacks merit. The District Court denied Respondent's presidential immunity claim and his related double jeopardy claim. The Court concluded that the Constitution's text, structure, and history support the conclusion that Respondent, quote, may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office, end quote. Although the Constitution's text does not address presidential immunity, the Court observed that silence did not reflect an understanding that a former president possesses immunity from federal criminal prosecution for acts taken while in office. To the contrary, the Court explained, the one constitutional provision that Respondent invoked, the Impeachment Judgment Clause, United States Constitution, Article 1, Section 3, Clause 7, cut against his immunity argument. The Impeachment Judgment Clause provides, "Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law." United States Constitution, Article 1, Section 3, Clause 7. The court noted that the clause's first part, quote, "limits the penalties of impeachment to removal and disqualification from office," end quote, and the second part clarifies that the party convicted may face later criminal prosecution, but that any further punishment may not come from the legislature. The district court reasoned that several features of the Impeachment Judgment Clause undercut respondents' assertion that it confers any immunity from criminal prosecution. First, the term "nevertheless" clarified that the clause's first part addressing the penalties that the legislature could impose following impeachment, quote, "does not bear on whether the party would also be subject to criminal prosecution," end quote. Second, materials written contemporaneously with the Constitution, such as those from Alexander Hamilton and James Wilson, did not reflect the view, let alone a widespread consensus, as respondent contended, that the Impeachment Judgment Clause renders former presidents immune unless they were impeached and convicted. Third, respondents' interpretation of the Impeachment Judgment Clause relied on a negative implication that a president who is not convicted in an impeachment proceeding cannot face criminal prosecution that reflected neither logic nor common sense. Finally, respondents' interpretation would produce the untenable anomaly that a former president would be immune if he committed a crime that was not treason, bribery, or other high crimes and misdemeanors, United States Constitution, Article 2, Section 4, for which impeachment is not available, committed the crime near the end of his presidency, or covered up the crime during the time of his presidency. Turning from text to structure, the district court reasoned that the public interest in a former president's criminal prosecution outweighs the theoretical asserted burden such a prosecution entails. Concerns about chilling presidential conduct were minimal, the court noted, because, quote, "whether to intentionally commit a federal crime," end quote, should not be among the difficult decisions a president faces. In addition, the court stated, the possibility of vexatious post-presidency litigation was, quote, "much reduced in the criminal context," end quote, given, quote, "robust procedural safeguards attendant to federal criminal prosecutions," end quote, that protect former presidents from harassment. By contrast, quote, "the public interest in fair and accurate judicial proceedings is at its height in the criminal setting," end quote. Holding a former president criminally accountable, the district court observed, is, quote, "essential to fulfilling our constitutional promise of equal justice under the law," end quote, and furthers, quote, "the public interest in an ongoing criminal prosecution," end quote. The district court also found nothing in history to justify the absolute immunity that respondents sought. The court discerned, quote, "no evidence that the founders understood the Constitution," end quote, to bestow such immunity, and the executive branch had, quote, "expressly and repeatedly concluded that a former president," end quote, "was subject to criminal prosecution." President Ford's pardon of former President Nixon aimed to prevent the latter's potential criminal prosecution, demonstrating that respondents' view of presidential immunity from criminal liability, quote, "stands at odds with that of his predecessors in the Oval Office," end quote. In addition, the district court noted that Fitzgerald had analogized a former president's immunity from civil liability, quote, "to the similar protections provided to judges and prosecutors," end quote. But the court explained that, quote, Notwithstanding their absolute civil immunity, prosecutors and judges are subject to criminal prosecutions, as are other citizens. In sum, the district court concluded that former presidents, quote, do not possess absolute federal criminal immunity for any acts committed while in office, end quote. The court similarly rejected respondents' claim that his acquittal in impeachment proceedings afforded protection under double jeopardy principles or the impeachment judgment clause against his criminal prosecution after leaving office. Reasons for granting the petition. A cornerstone of our constitutional order is that no person is above the law. The force of that principle is at its zenith where, as here, a grand jury has accused a former president of committing federal crimes to subvert the peaceful transfer of power to his lawfully elected successor. Nothing could be more vital to our democracy than that a president who abuses the electoral system to remain in office is held accountable for criminal conduct. Yet respondent has asserted that the Constitution accords him absolute immunity from prosecution. The Constitution's text, structure, and history lend no support to that novel claim. This court has accorded civil immunity for a president's actions within the outer perimeter of his official responsibilities. See Nixon v. Fitzgerald, 1982. And the executive branch has long held the view that a sitting president cannot be indicted while in office, but those principles cannot be extended to provide the absolute shield from criminal liability that respondent, a former president, asserts. Neither the separation of powers nor respondent's acquittal in impeachment proceedings lifts him above the reach of federal criminal law. Like other citizens, he is accountable for criminal conduct. The district court presiding over this case rejected respondents' constitutional arguments and has scheduled trial for March 4, 2024. Respondents' notice of appeal, however, suspends trial proceedings. See Griggs v. Provident Consumer Disc Company, 1982. Per curiam. And respondent has moved for a stay of all proceedings in the district court while his appeal is pending. It is of paramount public importance that respondents' claims of immunity be resolved as expeditiously as possible and, if respondent is not immune, that he receive a fair and speedy trial on these charges. The public, respondent, and the government are entitled to nothing less. Yet if this case proceeds through the ordinary and even a highly expedited appellate process, it is unclear whether this court would be able to hear and resolve the threshold immunity issues during its current term. For that reason, the government seeks a writ of certiorari before judgment to afford this court an opportunity to grant review now and ensure that it can timely resolve the important immunity question presented here. The United States recognizes that this is an extraordinary request. This is an extraordinary case. The court should grant certiorari and set a briefing schedule that would permit this case to be argued and resolved as promptly as possible. A. This case warrants this court's immediate review. This case satisfies the standards for certiorari before judgment. The court has jurisdiction to review cases in the Court of Appeals by writ of certiorari before or after rendition of judgment or decree. 28 U.S.C. 1254-1. An application for a writ of certiorari to review a case before judgment has been rendered in the Court of Appeals may be made at any time before judgment. 28 U.S.C. 2101-E. A writ of certiorari before judgment is appropriate when, quote, the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in this court. End quote. Supreme Court Rule 11. This case involves a paradigmatic issue of imperative public importance: the amenability to criminal prosecution of a former president of the United States for conduct undertaken during his presidency. It requires no extended discussion to confirm that this case, involving charges that respondent sought to thwart the peaceful transfer of power through violations of federal criminal law, is at the apex of public importance. The charges implicate a central tenet of our democracy, and the charges allege that respondent conspired to transgress the law in manifold ways. By intentionally using fraudulent means to obstruct the presidential electoral process, by obstructing constitutionally prescribed processes in Congress for counting electoral votes, and by seeking to deprive millions of voters of their electoral choice for president. The district court set this case for trial on March 4, 2024, to, quote, ensure fulfillment of the public's interest in seeing this case resolved in a timely manner, end quote. Quote, the public interest in a broad sense, as well as the constitutional guarantee of a speedy trial, commands prompt disposition of criminal charges, end quote. Strunk v. United States, 1973. Vindicating that public interest in this case requires immediate resolution of the immunity question to permit the trial to occur on an appropriate timetable. If appellate review of the decision below were to proceed through the ordinary processes in the Court of Appeals, the pace of review may not result in a final decision for many months. Even if the decision arrives sooner, the timing of such a decision might prevent this court from hearing and deciding the case this term. Precedent supports expeditious action. When the government sought certiorari before judgment in United States v. Nixon, 1974, a case presenting similarly consequential issues of presidential privilege, the court granted the petition and resolved the constitutional question expeditiously so that trial could begin as scheduled. There, the district court overseeing one of the Watergate cases had scheduled trial to begin on September 9, 1974. On May 24, 1974, the special prosecutor sought certiorari before judgment following the district court's denial of former President Nixon's motion to quash a subpoena seeking Oval Office recordings. The court granted certiorari a week later and set the case for argument on July 8, 1974. The decision issued 16 days later, and trial began in the fall of 1974. This case warrants similar action. As in Nixon, quote, the public importance of the issues presented and the need for their prompt resolution, end quote, merit this court's intervention now without awaiting the completion of appellate proceedings. And as in Nixon, that is true even though the district court correctly denied respondents' presidential immunity and related double jeopardy claims. While no precedent supports respondents' claim as a former president to criminal immunity, the government acknowledges that this court has not addressed a comparable claim. And this is a quintessential example of, quote, an important question of federal law that has not been but should be settled by this court, end quote. Supreme Court Rule 10c. In recent years, this court has often granted certiorari before judgment in cases of imperative public importance that warranted an immediate determination by this court. See, e.g., Department of Education v. Brown, 2023, Biden v. Nebraska, 2023, United States v. Texas, 2023, Whole Woman's Health v. Jackson, 2021, Department of Commerce v. New York, 2019. It should follow the same course here. B. The court should order expedited briefing so that it can consider and decide this case promptly. The government is filing this petition for a writ of certiorari before judgment, not only because of the public significance of the issues, but to ensure that the case may be briefed, argued, and decided during the ordinary decisional time for cases argued this term. As noted above, the district court has scheduled trial to begin on March 4, 2024, and respondent has appealed. Given the uncertain timing of appellate proceedings in the ordinary course, including potential requests for rehearing en banc, certiorari before judgment is appropriate now to allow the court to provide the prompt and definitive resolution that the issues presented here require. Because of the discretionary nature of this court's consideration of this petition and to avoid any potential delays, the government is concurrently filing a motion to expedite proceedings in the D.C. Circuit, which currently has jurisdiction over the appeal. As that motion explains, the government is seeking prompt resolution of the appeal in time to allow this court to hear and decide the case this term, in the event the court opts not to grant the petition for a writ of certiorari before judgment. If the court grants review, the government respectfully requests that it establish a schedule for briefing and argument that would allow the case to be resolved as promptly as possible. Alternatively, if the court opts not to grant review immediately, the government respectfully suggests that it consider postponing action on the petition pending further proceedings in the Court of Appeals, so the court could grant certiorari immediately upon the issuance of a decision by that court. Cf. DHS v. Regents of the University of California, 2020. And if the court elects not to review this case at this time, it may wish to note that the Court of Appeals should proceed with sufficient dispatch to permit the court to hear this case promptly during its currently scheduled argument sessions for this term. See e.g. Trump v. Hawaii, 2017. Conclusion. The petition for a writ of certiorari before judgment should be granted. Respectfully submitted, Jack L. Smith, Special Counsel; J.P. Cooney, Deputy Special Counsel; Michael R. Drieben, Counselor to the Special Counsel; James I. Pierce, Assistant Special Counsel. December 2023. Appendices totaling 60 pages in length have been omitted from this audio recording. This concludes this episode of The Docket. I hope you enjoyed this episode. For updates on the docket, please visit docketpod.com or find us on Threads as DocketPod. If you found this useful or interesting, please consider subscribing to the docket and supporting my Patreon at patreon.com/docketpod. Thank you.